This is Steve Zeltzer with WorkWeek Radio, and we've covered the case of Bryan Carmody, who was arrested here in San Francisco, a journalist, independent journalist, freelance, and had to fight to get his equipment back, and also the action of the police and the judges who allowed him to be arrested, and the kind of struggle he had as an independent journalist. I'm with Dave Snyder. David Snyder, he's the director of First Amendment Coalition, who's been involved, his organization has been involved in defending the right of journalists. Welcome to WorkWeek, David.
Thank you for having me.
So David, why don't we go to the story of Bryan before we get to Jeremy's case. That was a case in San Francisco. Can you talk about that and how your organization got involved in that?
Yeah, the Bryan Carmody case took place in 2018 in the city of San Francisco. And Bryan awoke one morning to the sound of police battering ram at the front door of his house. And the police came in and informed him that they had a warrant, and they put him in handcuffs and carted off pretty much every electronic device along with some other materials that he had. The catch here for purposes of my organization and really the world at large is that Bryan is a journalist, and California law is very explicit that search warrants cannot be used to go through a journalist's unpublished materials. And that's what the police in the Bryan Carmody instance were trying to do. They were trying to find his source for a police report that he had distributed as part of his journalistic work. And so we at FAC connected Bryan immediately with a lawyer who could represent him. That's Tom Burke, a terrific media lawyer in San Francisco, who represented Bryan in getting the warrant quashed. Simultaneously, my organization, along with others, moved to unseal the warrant applications in Bryan's case, because as it turned out, the police had multiple warrants, had been able to get multiple warrants for Bryan's gear from both his office and his home. In the end, Bryan had his materials returned to him with some assurances that they were not gone through and that any copies had been destroyed. And I believe he settled with the city of San Francisco for somewhere just short of $400,000. So it was really an egregious case of this, the government obtaining a search warrant, again, where California law could not be more clear that search warrants are not allowed in circumstances like this, where what they're looking for is a journalist's unpublished materials. And in the end, I think Bryan got back what had been taken, and he settled for the amount that I mentioned. But it remains, I think, a real stain on the city of San Francisco, at least the government, from that time. It's just not a city that you think of as acting in an authoritarian way, but that's certainly what they did in the instance of Bryan's case.
It is state law, the SHIELD Act. What exactly does the SHIELD Act say, and was it enforced in the case of Bryan Carmody?
So the California Journalist SHIELD Law is part of the California Evidence Code as well as the California Constitution. And what it essentially says is that first and foremost, police have to, if they want to look at a journalist's unpublished materials, they've got to get a subpoena. And even if they get a subpoena, their ability to access those materials is very, very limited. It provides very strong protections for journalists' unpublished materials, including but not limited to confidential sources. And so it makes clear that those materials are protected, that journalism relies on the ability of journalists to speak with sources confidentially and not to have the materials that they gather during the course of their work used as a kind of investigative arm of the state. So it's highly protective. It's one of the better journalist shield laws in the country. And again, one of the things that it makes very clear is that search warrants are a no-go. Search warrants do not allow for a journalist to come into court and make arguments as to why the state doesn't get to see their unpublished materials the way a subpoena does. Rather, a search warrant is a way that the police are able to simply just seize material after a judge has authorized the warrant with no argument, no discussion, and then they have it. And so search warrants really present a profound hazard to the ability of journalists to do what it is they do.
Well, were the San Francisco police aware that he was a journalist when they went to get a search warrant?
Yeah, that's a very good question. And that's one of the questions that we were hopeful we'd be able to answer after unsealing, and we did successfully unseal the search warrant applications. And I think it's clear from viewing those warrant applications that they did know. They don't say it particularly explicitly, or didn't say it explicitly to the judge. So did the judges know that Bryan Carmody is a journalist? That's unclear. And the warrant applications changed a little bit over the course of, there were multiple, and the content of those didn't remain consistent across the applications. In the later applications, it became more clear just on reading the face of the warrant application, which was presented to the judge, that Bryan Carmody is a journalist. But to me, speaking on my own behalf, it seemed fairly clear that the police knew that he was a journalist and sought to obscure that fact when they went to ask for a warrant from the judges that they asked for them from.
If it was the case that he was indeed a journalist, they knew about him being a journalist, then where's the accountability?
Another really good question. Yeah, I mean, if they knew he was a journalist, they should have known that they shouldn't have even been trying to get a warrant. And we pushed for accountability at the level of the police department, at the level of the mayor's office. We didn't get a lot of traction there. As you may recall, the circumstances surrounding the warrant that was served and executed on Bryan were highly politicized. It related to the death of Jeff Adachi, a revered figure in San Francisco political circles. And the police report that Bryan obtained and then distributed to at least one news station, I believe, detailed some of the circumstances surrounding Jeff Adachi's death in a way that fans of Jeff Adachi, of which there are many, and I think justifiably so, did not like. And so there was a real kind of across the board political push, at least in the very early hours and days of this scandal, to figure out who leaked this police report. Once people realized that this was an unconstitutional search and seizure, the tone changed somewhat, but we never really saw ultimate accountability for these really profound failures. And that wasn't for lack of trying on the part of my organization, but we are a small organization. There's only so much we can do. There was a lot of political will initially behind ferreting out who the source was for this police report. And I just want to emphasize that this wasn't a secret document. It's not like the material divulged could jeopardize national security or contained information that was clearly supposed to be confidential. It was a police report. And the police departments in California are permitted to withhold those reports from the public, but they're not required to. These are not, it's not a document that's confidential by law, but again, there was very intense political pressure to determine how this document got in the hands of the press.
And was there ever a request made of the district attorney or state attorney general to investigate?
To our knowledge, to my knowledge, or to my memory and knowledge, no, but it's been a few years now. I don't believe so, but I may not be remembering correctly. But in any event, I don't believe there was such an investigation.
Do you need a request to get an investigation?
I wouldn't think so. I don't know the specific internal process at the California AG's office, but I don't think they're required to. I don't think their investigations necessarily have to be prompted by a specific request.
And now we have the case of Jeremy Portje, Why don't you talk about who he is and how your organization got involved in his case?
Sure. So Jeremy and Portje. Jeremy is a freelance journalist, a photographer, and videographer who was on November 29th filming at a homeless encampment in Sausalito. And there was some sort of interaction with the Sausalito Police Department, which led, all the details of which we still are not totally clear on, but in any event, they led to Jeremy's arrest. And when Jeremy was arrested, the police, the Sausalito police, seized all of his equipment. So a cell phone, a camera, tripod, a couple of electronic storage devices, a drone, I believe, that he uses for filming. They seized all of those, booked them into evidence. Jeremy was booked on charges, I believe, of battery on a police officer resulting in injury. And I think there were a couple of other charges. He was out on bail, I believe, after a night in jail. We didn't hear about this at FAC until a few days later. It was initially reported by the Pacific Sun, a weekly newspaper. And as soon as we heard about it, we mobilized to let the Sausalito Police Department and the mayor's office and the district attorney in Marin County know that while we didn't know all the details of the arrest, it appears to have some problems from a First Amendment perspective. It is not a crime, and you can't be arrested for simply filming something, and in particular police activity, in a public space. And that's what Jeremy was doing. Now, we were clear that we didn't then and still don't know all of the details of the interaction between Jeremy and the police officers. But we said, look, there are probably looks like there's some serious First Amendment issues here. Clearly, there are issues, we said in our letter, with respect to the seizure of his equipment. That equipment should not have been seized, consistent with the California Journalist Shield Law and also probably the First Amendment. And there's a federal law that is in play as well called the Privacy Protection Act. And we outlined how his materials should not have been seized at all. And then finally, although as it turned out, most importantly, we emphasize that now that you have these materials, you can't get a search warrant to look into them. And we explained what I explained earlier, that search warrants are expressly and unequivocally barred under California law because Jeremy's a journalist and these are his materials. And so we laid all that out. We sent that letter on December 7th. And then we learned later that 2 days after we sent that letter, again to the police chief, the mayor, and the DA, the Sausalito police sought and received a warrant to look into the equipment from Jeremy that they had seized. So storage devices, his iPhone, the camera, to the extent it had any of storage capacity of its own, which I don't think it did. And when we learned about that, we again mobilized very quickly for a brief letter the day we heard about this and said, look, you should not have gotten a search warrant. As we explained in our letter of a week and a half ago, this is a real problem. You can't look at any of his materials. You shouldn't have been able to get a search warrant. As it shook out, the DA has made assurances that the storage devices that none of the materials that were actually looked at. So there was a search warrant obtained. That search warrant was executed in the sense that the police took the storage materials and sent them to a computer crimes lab, and they downloaded some of the material on his storage devices onto a computer. But the DA has made assurances that there was never anything looked at. So all of that is kind of where my organization played a role. He has a criminal defense lawyer who's been representing him, who has been making some of the same arguments to the court. He filed a motion to quash the search warrant and have Jeremy's materials returned to him. The last I had heard, and I haven't had an update in a few days now, but the last I had heard, Jeremy's lawyer and the city officials we're working on an agreement by which Jeremy's materials will be returned to him with assurances that they haven't been looked at and won't be looked at. So as things stand now, that was an unlawful search warrant. But if the DA's assertions are to be believed, and I don't have any specific reason to think that they're not true, police were not able to actually look in and see the materials that were on Jeremy's devices. And so as far as it goes, that's good. But what happened here should never have happened. There should never have been a search warrant. I think it's likely that there really was never any cause for Jeremy to be arrested. And, it's another instance of police overreach that could have had, what did have serious consequences for Jeremy for sure, but could have had even more dire consequences. And it sends a signal that there is a startling lack of awareness of or respect for the law that protects journalist sources in California and federally. There's a federal law in place too. I should add, just in concluding the basic description of this, that the DA determined that they're not going to file charges against Jeremy. There was not, the DA, I think, explained it by saying they've got to prove a case beyond a reasonable doubt, and they didn't think there was evidence to do that. So he's not being charged with any crimes. He was booked on suspicion of several, but the DA is not going to bring those charges.
And I understand one of the charges was a criminal conspiracy, that he was involved in a criminal conspiracy. I mean, it sounds preposterous.
It does.
I mean, he's been covering these protests for a long time, that he would be involved in a criminal conspiracy.
Yeah, and the contours of this alleged conspiracy are very vague. They're alluded to in the search warrant application. There seemed to be some allegation that he was working with others to make the police feel uncomfortable or make them feel bad or something. I mean, it looked to me like they were alleging a conspiracy to cover the police, which, if that's a conspiracy, then journalism as a whole is a criminal enterprise. And as crazy as things are in this country at the moment, I don't think we've gone that far just yet.
Well, when you sent them a letter saying that they should not pursue any more warrants because he was a journalist, and they went ahead and did that action, is that a violation of law?
Well, I think it was a violation of law the minute they sought and then obtained the search warrant. In fairness, I sent this to the police chief, and I sent it to all the contact information we could find for him, including his email address, a fax number, and we also mailed a hard copy through the US mail for what that's worth. But that doesn't mean that necessarily that he ever saw it or that it was relayed to his officers. But as an institution, they were certainly on notice that a search warrant could not be obtained. But that shouldn't even be necessary. The law is what the law is, and the officers and other government agents who are charged with obtaining search warrants are charged with knowledge of what the law is. So I think it was a clear violation of the California Journalist Shield Law from the minute the search warrant was obtained, and then sought and then obtained, and then ultimately executed. At least it was executed, at least in the sense that some information was downloaded from Jeremy's storage devices. We have assurances from the DA that nothing was actually looked at. And so I think there's a kind of semantic argument. Does that mean that the search warrant wasn't executed? I think kind of as a formal legal matter, it was executed. They extracted information from the devices as to which they'd obtained the search warrant. And again, it's good if it's true that none of that stuff was looked at, but there's no way, I guess, of knowing that for absolute certainty.
And the judges in the case of Bryan Carmody, apparently some of them may have known that he was a journalist, and they issued the search warrants. In the case in Marin County, were these judges aware that he was a journalist?
Yeah, so in Bryan Carmody's case, there were at least 5 separate warrants. To our amazement, we initially thought there was just one, and I think it was 5 separate judges. In Jeremy's case, just 1 warrant and just 1 judge. So did the judge know that Jeremy is a journalist? Well, the application for the search warrant filed by the Sausalito Police Department does use the word journalist, but I think it only uses it once. And it uses it to say that Jeremy is quote, not a true objective journalist. So it spends a lot of time explaining how what he does is go out and film the police, and they appear to sort of try to allege that what he's really doing is just harassing the police and bothering them. But they don't ever come out clearly and say, by the way, Jeremy Portje is a journalist, again, except in a kind of negative way, to say he's not a true objective journalist. And so one of the points we made in the documents that we've prepared for this, so we sent 2 letters, and we also filed a friend of court brief along with the motion to quash that Jeremy's lawyer filed. And in those papers, we made clear that one officer or any government employee's opinion about whether a journalist is objective or not doesn't have any, it's not relevant. It doesn't matter. If what they're doing is journalism, then they're a journalist. It doesn't matter if one officer or even an entire city or department thinks that they're not objective. That does matter for application of the Shield Law. So, you know, did the judge know? Well, if you read that application very, very carefully, I think the judge could reasonably be said to have been on notice that Jeremy is a journalist. And so then the question is raised, well, why did a search warrant issue then? And I don't know the answer to that question, but it bothers me.
And have you raised with the district attorney the need for an investigation and possible prosecution of these police officers and even the judge for violating the SHIELD Act? We
did ask in at least in our initial letter. I don't recall if we did in our follow-up letter, but we did ask that the police officer's conduct be investigated. And I think it should be. I don't think, based on what we know now, it's not at all clear to me that they behaved appropriately from the beginning of the interaction with Jeremy. The allegations were that Jeremy's camera hit the officer's face and caught one of the officer's face and caused a scratch on his eye. The reporting by the Pacific Sun and their reporter, Nikki Silverstein, and she talked to a witness or 2, maybe more, who saw the interaction, and they said that that the camera hit the officer accidentally. How that happened, I don't exactly know, but it sounds like what happened was he had pulled the camera away from Jeremy and it came and hit him in the face. Anyway, you know, the allegations were battery on a police officer, and I just, based on the facts we know now, which again are not complete, I just don't see that what we understand to have happened at this point, you know, rises to the level of him being charged. It's a whole other question why they thought they needed a search warrant to prove what in the end are, you know, pretty minor charges, even if they had a basis to begin with. Like, what, even if you accept that those crimes happened the way the police alleged they did, why the need for a search warrant to go through all of his materials? And, you know, I believe he had materials on those storage devices, perhaps on the iPhone as well, that relate to his journalism work going back probably a couple of years. So there's probably a lot of material there that the police have no right to see.
Would that be part of a criminal conspiracy on the part of the police?
Oh, yeah, and, you know, I haven't put much thought, so I'm not a criminal lawyer, and I really haven't put much thought into what if there were a prosecution of the police. So I'm not really equipped to answer that question. I think the starting point is, at a minimum, is the department or the state AG's office looking into this? Is there going to be an internal affairs investigation to determine whether the police followed police department procedure and or California law? Another, so yeah, will there be a prosecution of the police? I don't know that it's a criminal violation to violate the California Shield Law. It is certainly unlawful to do so, but I think the way of enforcing that kind of a violation would be to file a civil rights lawsuit and try to get a judgment against the agency that violated that law.
And the Attorney General, Rob Bonta, as you were saying, he doesn't need somebody to call on him to make an independent investigation. Do you think your organization, other organizations should be calling on him to do that?
Yeah, I don't believe he has to have an invitation, as it were, although I don't know that for sure. But I think I think there should be. And I would, before going down that road, I'd want to understand the contours of when and how the AG gets involved in local law enforcement matters to investigate them. I think, again, the first step is to see that the department itself is even starting any investigation. But the AG's involvement, I think, is warranted as well. I mean, this was a violation of the state constitution, and that's important, obviously. And it's alarming to me that we've seen two instances of this, of police obtaining a search warrant for a journalist's unpublished materials in the span of 3 years. When the Bryan Carmody incident happened, I couldn't believe my ears when he called me not long after after the police took the handcuffs off and let him out after they'd searched his place, and I had to sort of ask some questions to make sure that it wasn't somebody with a tinfoil hat calling me, because it's outlandish that the police would, not just that they would get and execute a search warrant, but you may have seen the footage or the stills from it. They had a battering ram. There were like 6 of them at his front door with a battering ram to find out who ultimately, who was the person who made sure that a police report was released to the public, which, again, a police report is not, it may be confidential by San Francisco Police Department policy, but it's not under California law, it is not a confidential document. Police departments have the ability to release it. So it wasn't something super secret, but it was something that had a lot of political will behind it. And so there was intense political pressure on the police department, I'm sure, to ferret out who the source for that document was.
But what does it say in general about the enforcement of this SHIELD Act, that it's apparently the case that the police departments and even judges feel they're not bound by that law?
Yeah, I mean, I think there's a question in both of these cases about whether the judges and the police departments were even aware of the law. Now, again, like, especially as a judge, you're sort of charged with knowledge of the law. But if the party in front of you isn't telling you some important facts, then a judge can be forgiven for not knowing the law. I think I have not seen evidence that there is a contempt or a disregard of the law. What I do think is a problem is an ignorance of the law. So one of the things that we at FAC, along with the Society of Professional Journalists Northern California chapter, have proposed to the authorities, the judicial authorities in California, is let us do a training for judges when they do trainings, just to remind them about the SHIELD law and its scope and how it applies and why it matters, and in particular in the case of search warrants, why it is important. We haven't been able to nail that down yet, but at a minimum, I think it speaks to a troubling ignorance of the law. I'd like to think, and I could be wrong, and maybe I'm being Pollyanna-ish, but I'd like to think that there's not, and I haven't seen any evidence of there being any kind of a groundswell of resistance to or disregard for the law. I think it's more a matter of ignorance. Not that that's any better in terms of the ultimate outcome. But I do think that there is still a respect for and an understanding of the importance of journalists in our society. There is, at the same time, journalists have faced really incredible headwinds nationwide from many corners, whether they're political or legal or what have you, that are really troubling. Journalists' ability to just do their job is getting harder and harder, and that's a problem for democracy.
Of course, the past president said that the journalists were scum. So,
enemy of the people was, I think, the direct quote.
The last question is, being that in your view and many others, the law is being violated, has the Attorney General Rob Bonta put out a notice from the Attorney General's office to give a heads up to judges and police departments throughout the state that they need to respect the SHIELD Act?
To my knowledge, no, but that would be a welcome message. The Attorney General of the state of California has quite a bit of bigger platform and a louder megaphone than David Snyder at the First Amendment Coalition. So that would most certainly be a welcome message from Attorney General Bonta.
Well, I want to thank you for joining us. We've been talking with Dave Snyder. He is the executive director of the First Amendment Coalition, talking about cases concerning journalists who are being attacked, whose equipment is being seized, and threatening the right of journalists and the right of the public to know information that is important to them. So thanks for joining us on WorkWeek.
Thank you for having me.